all the guests and attendees. I'm extremely grateful for this opportunity by the organizing committee, a great effort. Just picking up from Professor Preetham's observations on dignity, I primarily agree on the question of the fact that dignity, the idea of dignity is really derived from yes, in this one. Yes. Am I audible now? Yeah. It's very difficult to gauge it. Yeah. So coming back to the idea of dignity, I'm quite certain, and I certainly agree with Professor Preetham on this point, that what in philosophy we call as morally thick concepts or prescriptive concepts, that they are laid with a whole tier of meanings, right? And therefore, one of the things which one has to observe as especially within the philosophy of language, while dealing with these kinds of concepts, is to look at the synonymical meaning of these concepts. Like, as he was saying, worth, value, it goes on to rank, status, and so on, right? So that part I primarily agree with. Where I have my reservations is, as a realist, as you would see here in this presentation, I'm not so much preoccupied with the problem of contradiction on the meaning of dignity, especially within constitutional jurisprudence, because from the realist point of view, most of the real human problems, as I think Professor Murli was also pointing out, from the clinic point of view, they really don't come to us in some neat categorizations and any kind of a sanitized version, right? Most of them are bombarded like with mixed factors and mixed causations and mixed categories of concepts, right? So at any point of time when you actually deal with litigations and real problems of human beings on the matters of human dignity, it would not be very worthwhile to be trying to search for that non-contradictory, prescription of any kind of a morally thick concept, including dignity. On that point, and since he invoked Wittgenstein, so I would rather say that these morally thick concepts are like, they belong to a certain life form. Every single iteration of meaning of dignity that you derive, it would have some parent background ideology behind it. And in most of the clear, landmark cases of Supreme Court also, you'll find that there's almost like this fierce contestation of those ideologies in terms of trying to search out for the meaning of that particular problem of dignity in that case. And one such case we have with us is this Lieutenant Colonel Nitisha versus Union of India. This seems to be the latest iteration of Supreme Court on the doctrine of indirect discrimination and constitutional equality under Article 15 and 16. And while working on this particular paper, we did draw on certain primary insights from moral realism to come up with this whole challenge and problems of dignities, which I'll briefly put down before you here, depending upon the time context, right? Coming back to the question of the historical idea of dignity, which Professor Preetham was talking about, I think broadly the way I see it is when you go back to the root meaning here, dignitas and the worth and the value of the question of the human person, one of the preoccupations of law, regulation, and moral philosophy has been to look at the negative side of it. That is the silencing of dignity, the undermining of dignity, this whole idea of debasement or subordination of a human being. That is where we mostly pitch the whole notion of dignity. And when you start framing the question from that problematic lens, that dignity is mostly about, within law, regulation, and moral philosophy, it is mostly about a question of its absence, silence, subordination, and domination, right? At once you start seeing a certain kind of an emergence of a prescriptive meaning of dignity, which is held by two important intellectual pillars within Western tradition particularly. One, he has already mentioned, the Kantian deontological tradition, which later morphs into contractarianism of John Rawls and others, right? But the other one, which we have almost passed out, which is socioeconomic rights and those aspects of it, which is the tradition of utilitarianism, right? And these two pillars together constitute one of the linchpins of the constitutional jurisprudence of your dignity rights mostly. One pillar being utilitarianism and the other being deontological contractarian agency and contextual freedom. So that is how, so far, so I can see, I would broadly categorize the constitutional ethos of dignity. Now, what is very keen here to look is, what do these two schools of thoughts really bring in terms of constitutional jurisprudence and their repercussion on the doctrine of state action mostly, right? So when we come to the whole idea or the whole intellectual tradition of utilitarianism, you'll find that, I mean, both of them are tied up with one single fact, because in law and regulation, the problem is that of avoiding debasement, subordination, and domination, and therefore somehow trying to, right, maintain the status quo of a minimal standard of human decency. That is where most of the benchmarking of law and public policy is, mostly, right? with the question of human dignity. When we take both these pillars of intellectual traditions and see how do they maintain this status quo or this least common multiple, so to say, right, of human dignity, they come up with very different solutions for us. One, which comes from utilitarianism, is this extrinsic materialist account of human dignity that basically what we call as roti kapda makan thesis, a food, shelter, clothing thesis. It at once gives us the imagination of a welfare state, a regulatory state. What you'll find is this: it gives us a certain archetype of constitutional state action, and that is interventionist. That is interventionist. So it is not that Article 13 imagination of state action, state shall not do this. It is rather state shall go ahead and intervene in these affairs and secure the minimal standards of human decency, which is basically food, shelter, and clothing, and those whole range of rights. So this is where most of the ideological discourse of utilitarianism comes in when it informs our jurisprudence of dignity within constitutional law. Another way to put the same idea would be what I would call, drawing from Michael Mann's work, the, the sources of social power, and also Michel Foucault and others. This account of dignity almost seems like an infrastructural account of dignity, a resource-based account of dignity, where one of the important markers of our dignity, it seems to be our capacity to acquire, distribute, allocate, and also consume relevant material resources, right? Which is roti, kapda, and makan, and those archetypes, right? So this is an infrastructural account of dignity, which is mostly informing regulatory theories, public policy, public education, public health, and most of the other clinical programs mostly are dominated by this ideological discourse of dignity. On the other hand, when you come to the deontological and the contractarian account of dignity, is that your typical Article 13 state action account of a non-interventionist, a state respecting a certain sphere of human agency, contractarian agency, rational choice. And that is where this intrinsic account of human dignity primarily comes from, that human beings, all human beings are laced with certain intrinsic capacity of rationality, and that rationality must be respected within contractual relations. So that is where we get this state shall not do X, Y, and Z under Article 13, right? So just by drawing out these two intellectual pillars of human dignity, you could almost see two imaginations of state action here: the welfarist state action, the regulatory state action, and then the canonical Thomas Paine legal constitutionalism style state action of rule of law, procedural fairness, and dignity basically becoming a product of rules, systems which promote consent and non-coercion. That is a typical Kantian account of human dignity. In this paper, though, we have tried to basically critique that account from the school of moral realism, and also to identify certain interfaces between critical theory and moral realism. That is where the play of the word post-feminism here is basically. So I'll briefly state out this short judicial story for you in this presentation, but I will try to narrate it as a cautionary tale, as a parable. And that is where this key term post-feminism is. It is basically a placeholder for that cautionary tale, that what are some of the typical blind spots of the liberal imagination of rights-based dignity, right? Now, if I get time, then maybe we'll venture further, but I'll just lay out the cards for you here. And then in the discussion, we may move further. Coming back to the case itself, this is a 2021 judgment of Supreme Court. As I said, it is the latest iteration on the doctrine of indirect discrimination. In some of the law schools, the case has already been brought in the course manual and it is being taught. It has a 20-year case history, right? So the starting struggle began from 2003 Delhi High Court, and ultimately it was finalized in 2021 by the Supreme Court in the Nitisha case. The case primarily pertains to the claims of women Short Service Commission officers, WSSCOs, their claim for permanent commission, their claim for promotion to permanent commission. As we know, permanent commission comes with a whole range of employment benefits, and that is a direct bearing on the question of dignity, right? Their internal, first of all, status and position within the military way of life, and also their whole source of livelihood and their long-term planning of a good life. So all of that is baked into the question of their promotion to permanent commission. They had been denied it, this whole claim for time immemorial almost, right? What we see in this particular judgment, that in 2020, in the latest iteration of it, in Babita Punia, basically, Supreme Court upheld the rights of these women officials to get the promotion and rank of the permanent commission within the military. And they articulated, basically Justice Chanchur articulated the entire problem as a problem of constitutional equality and doctrine of indirect discrimination, that the policies of the military bureaucracy mostly disproportionately affected the women as a gender class, right? And therefore, it was violative of Article 15, Clause 1, mostly, right? However, here is the first cautionary tale for us in terms of what went on. The government took this particular judgment of Babita Punia and it framed the policies in such a manner where, while outwardly there was a claim of gender, women empowerment and gender equality, however, internally, all those policies were administered in such a manner that none of the women officials could actually get promoted to the PC rank, right? And that is what led to the claim coming back to the Nitisha case, right? In Nitisha case, basically, Supreme Court made three major, findings of constitutional defect within the military's administration of the policies regarding the women officials. The first was their shoddy and casual maintenance of their performance appraisal records, which were confidential. So they were not accessible to the women employees, but they were maintained in a very casual and shoddy manner with a lot of clerical errors. Now, on the face of it, it looks like lapse of mind, right? But it was tagged up for most of the female officials, and therefore it led to those particular performance appraisal records becoming a non-show. They were not relevant materials to be considered for the promotion of the female officials. That was one trick, or if I use Michel Foucault's terminology, this was one governmentality trick, right? This was a trick of technology of rule making by the military bureaucracy to basically undermine the entire jurisprudence of constitutional equality and indirect discrimination as it applied in the Babita Punia case. That was the first. ACRs were compromised, their annual confidential reports. The second major trick applied by the military bureaucracy was in terms of maintaining their medical fitness standard, right? So what was done here was that because these female officials were in their senior ages by now, because they had not got the promotion. So while they were in the junior ranks, their age seniority was up to 45 to 55 years of age. What was basically done by the military bureaucracy was that the medical fitness criteria, which was applied as a normative baseline for 20 to 25-year-old male counterparts, the early entrants in the military, they were ipso facto applied on the senior aged female officials, and by that metric, none of them could actually beat the metric. And the government's simple conclusion was that these are the baselines for the medical fitness, and they have failed it, right? So this is a second trick applied by the bureaucracy, basically here, which leads to complete frustration of the Babita Punia's enunciation of constitutional equality, right? And the third, on which court only touches upon in Nitisha, but which we have picked up quite substantively, is going back to this narrativist account of human dignity and the lived experience part of it, when the female officials had no historical legacy of role modeling, mentorship, training in that military structure, right? Because there was none. And they had no futuristic imagination of a career project of promotion. That was also not there. So there's what I'm trying to say here is that these women officials were basically abstractions of analytical philosophy for the judges mostly, and also for the military bureaucracy. They had no history and they had no future, no past and no future, right? In that kind of a scenario, I mean, if we look at the idea of dignity as a longitudinal life project, right? That whole notion is absolutely debunked and destroyed, right? In this kind of problem. So they were just existing in the moment to moment kind of an ad hoc reality. That was their reality. What it does actually is this, that because of this absolute lack of longitudinal narrative account of the female agency within the military structure, these officials were not encouraged and motivated to take relevant compulsory courses for promotion. They were not exposed to skill upgradation programs at all, right? All the internal mechanizations of any institution for job promotions were absolutely not flagged out to these female officials. It would be something as absurd as like floating electives and not communicating to you students, or only to some of them and not to the others, right? And then the military comes back and says, well, they have not completed their credit course. That would be what it is, right? So this is the exact argument made by the military in Nitisha, that these female officials have not completed their credit courses to be promoted, right? And so these are some of the, you could say, tricks and mechanizations and technologies of rule making that lay bare the question of dignity from doctrine till administration. That is where my focus here is, right? That what doctrine leaves out, because from the point of view of the beneficiary citizen or the claimant, it doesn't matter what the doctrine has really said if at the administrative level it is absolutely undone, right? And The other major, we could say critique of the code that we have here is, this is not an early republic code. This is not an inexperienced code. This is a code with 75 years history of and experience of administrative review, right? So my humble, one of the explorations that we are going to do in future is on this whole idea of content of a judicial doctrine, especially constitutional law doctrines. They just can't be a romanticization and this whole, normative accounts of these thick moral concepts. They must actually take a realist approach on the question of potential risk assessments, potential, you can say leakages, right? Yeah, and therefore, coming back to Professor Preetham's argument, it is not so much contradiction that I'm worried about, but the non-robustness of the doctrine, that the doctrine absolutely fails in most of the circumstances, right? That is where the problem of Nitisha seems to be. How could I change the slide? This one here. Just so this is that account, because of lack of time, I'm not going to, but if you look at the second pointer here, this is what I was currently talking about, that this whole distance from doctrine or the constitutional doctrine to the administrative rulemaking is absolutely showcased in the problem of Nitisha. And maybe because of lack of time, I'll not go into the other part of it, but one point I also want to make here, this kind of a, problem of dignity throws open for us law students particularly this whole enterprise of judicial process, right? Its comparison with, let's say, common law adjudication versus constitutional law adjudication. These questions are thrown open, right? What kind of a, you can say, expectation should a constitutional doctrine, first of all, undertake and then also deliver on to? And my humble suggestion is this, that the constitutional doctrine must always, especially with this kind of a dispute, which itself has a 20 years data history, legacy point. This particular problem of the female officials is 20 years old. So the court could not really say that it did not have the relevant data metrics and the relevant, pointers to be able to anticipate these administrative risks, right? So a doctrine must be as mindful to administrative risks as it is mindful to the normative, philosophical, and the romantic content of it. That is one point we have. The second point I'll not speak because of lack of time here, which is the first point, which is the real crux of the matter on the question of the substantive ideological contestation of the dignity. So maybe in the discussion point, maybe we'll come back to it, right? So thank you so much, right?